Good afternoon, ladies and gentlemen. Welcome to this joint SIAC JDLC seminar on international arbitration in Singapore, key developments and insight for Japanese parties. My name is Eriko Kawakami, and I am pleased to be your MC this evening. We begin with a welcome address by Prof. Yoshihisa Hayakawa, who is the Executive Director and Secretary General of JDLC, a partner at Uju and Itoga, and Professor of Law at Rikkyo University. Professor Hayakawa, please.
Thank you very much. Thank you joining this seminar, which is jointly organized by SIAC and Japan International Dispute Resolution Center. We call it JDRC. I am Executive Director and Secretary General of JDRC. My name is Yoshihisa Hayakawa. JDRC is a newly established entity in order to promote international arbitration in Japan and to operate advanced hearing place for international arbitration. So we are not arbitration institution like a SIAC, and we are just providing the facilities for international arbitration. In other words, the SIAC is one of the best customer for us. And in reality, SIAC is the first arbitration institution with which we concluded MOU. And it is our very pleasure to have a joint seminar with SIAC for the promotion of international arbitration in Japan and in Singapore. Until recently, we established our Tokyo facility with a very advanced technology in April this year. But since then, until recently, we have experienced the many arbitration hearings here in Tokyo facility. But fortunately, we have experienced a hearing the case where the seat of arbitration is Singapore, but one of the venue of hearing is here JDRC. In other words, we are using hybrid style nowadays, especially in the COVID-19 disaster. So today, such a hybrid style is becoming very popular. So the one or more physical venues are connected by the remote access system, and we can smoothly operate our hearings by the such a remote system or high-tech IT technology. So today, this seminar is also conducted by such a hybrid style. Now I'm here, and today the first session moderator, Tony, is here as well in the physical place, and some participants here in this room. But at the same time, so many online participants is coming from Japan and from Singapore and from other countries. So thanks to the advanced technology nowadays, so that we can smoothly operate everything. So this seminar's purpose is to promote international arbitration in Japan as well. So I believe this seminar's final result will encourage the Japanese users the much more use of international arbitration in the very near future. So thank you very much, and thank you for coming to JDRC and SIAC this seminar.
Thank you, Prof. Hayakawa, for that warm welcome. We will now have Ms. Michelle Park Sonnen, who is the head of Northeast Asia at SIAC, say a few words on the new normal, Adapting International Arbitration During COVID-19. Michelle, please.
Thank you, Eriko. And thank you, Professor Hayakawa, for that warm welcome. Good evening, ladies and gentlemen. As Eriko mentioned, my name is Michelle Sonin, and I am the head of Northeast Asia at the Singapore International Arbitration Center. Greetings from SIAC's representative office in Seoul, where I am based, and from where I oversee SIAC's activities in Korea and Japan. SIAC is delighted to be co-hosting this seminar with our friends at the JIDRC. I also extend a warm congratulations to the JIDRC for its recent opening of the facilities in Tokyo, from where our moderator for the first panel, Tony, is going to be speaking today, and from where Professor Hayakawa just gave his opening welcome remarks. I am greatly looking forward to myself receiving an in-person tour, hopefully sooner rather than later. Although I do wish I could be in Tokyo delivering this presentation from the JIDRC, I'm grateful that we live in an age where I can address you virtually through platforms like Zoom. As Professor Hayakawa mentioned, SIAC and JIDRC are MOU partners, and I hope that this seminar will be the first of many collaborations between SIAC and JIDRC in the years to come. This year has been especially challenging for individuals and businesses around the world. The pandemic is truly a once-in-a-generation public health emergency. Along with the medical crisis, the pandemic has caused massive disruptions to the global economy and to international commerce. Entire industries have been forced to adapt to and embrace a new normal, as it's been called. As 2020 starts to come to a close, I think it's an opportune time to take stock of and assess the response of the international arbitration community. And I'll be speaking to you today about the institutional response, or the response of SIAC in particular. Back in March, when countries around the world started imposing lockdowns and travel restrictions, it was unclear what kind of impact the pandemic would have on cross-border dispute resolution. International arbitration is largely premised on the ability of parties and tribunal members and counsel and even institutions to be located in different jurisdictions across the globe. Arbitration stakeholders back at that time in March, they looked to institutions for guidance as to whether dispute resolution could proceed, and if so, what it would look like in these unprecedented times. SIAC and other institutions responded quickly and with creativity and adaptability to ensure that the international business community could continue to rely on arbitration as an effective dispute resolution mechanism. At SIAC, our most important priorities were ensuring that we continue to provide world-class case administration and providing users with up-to-date information about the status of our case management and our readiness to administer existing cases and commence new cases. In April, the president of the SIAC Court of Arbitration, Mr. Gary Boren, issued an open letter discussing the pandemic directly with users and stakeholders and assuring uninterrupted, efficient, and effective case management despite the pandemic. In addition, from March through September, SIAC issued 6 COVID-19 updates on the measures being taken at SIAC. These updates were emailed to our stakeholders around the world, and they are available on the SIAC website. The measures that we took at that time included remote work for most of our staff, or telecommuting, which was in compliance with the guidelines set by the Singapore government, and also responses that we took to ensure that case management would proceed uninterrupted. For example, we asked all parties to submit files electronically, provided contact information where the Secretariat could be reached urgently, and published a list of COVID-19 frequently asked questions which would address commonly asked questions about our procedures during COVID-19. We also implemented a live help desk feature on the SIAC website, where users have immediate access to an international arbitration lawyer at SIAC to ask questions concerning case management. This has been an extremely popular feature. We've answered questions like, how can I file my notice of arbitration during COVID-19? Can I submit a hard copy? If so, how can I do it? We've also answered inquiries regarding the requirements under our rules to utilize our time and cost saving mechanisms, such as the expedited procedure. The SIAC court has also continued its important work of deciding procedural applications, such as applications for consolidation and joinder, jurisdictional objections, and challenges to arbitrators. The court, which is comprised of 32 eminent arbitration experts from around the world, have relied on video and audio conferencing to deliberate. I am delighted that 2 of our court members are panelists in today's seminar, Mr. Hiroyuki Tezuka and Mr. John Bang. Mr. Tezuka will be speaking more about the role of the court in our second panel discussion later this evening. Recognizing that hearings would increasingly shift to virtual platforms, SIAC quickly began a training program for a number of SIAC counsel to be remote technology specialists. These specialists could sit in on remote proceedings if the parties in the tribunal so requested, and they could provide assistance to the tribunal and the parties. We also engaged in discussions with our stakeholders around the world to identify the most pressing needs and concerns of parties in light of COVID-19 and the increasing use of remote hearings so that we could adequately respond. The result of those conversations and our observation of cases proceeding during COVID was the release of the SIAC Guide, a series of user-friendly tools created by the Secretariat to assist parties and tribunals in conducting arbitration. The first SIAC Guide, entitled Taking Your Arbitration Remote, is in direct response to the increased use of virtual hearings, and it seeks to help users effectively navigate the use of audio conference, video conference, and other non-physical means of communication in their arbitration cases. I'm going to quickly show you a few pages of the guide to give you a better understanding of what it looks like. Are we able to put that in full screen? Okay, so this is the cover page of the guide. And then as you can see, if we go to the next page, the guide is presented in the form of checklists. The idea here is to set out practical checklists, practical points that any practitioner, party, or tribunal member can use when considering whether to utilize a remote hearing, and then also considering the procedure once they have decided to go forward with the remote hearing. So I'm not able to show you the whole document. I think it'd take up too much time to read through it all, but it is available on the SIAC website, and we do encourage you to download it and keep it as a reference. The checklist goes through various issues, including the suitability of a remote hearing in a particular case, any legal or contractual requirements to consider when determining whether a remote hearing should be adopted, and the accessibility of the necessary hardware, software, and even internet connection. It also raises issues concerning the timing and duration of hearings, particularly in light of the fatigue caused by extended use of computer screens, as well as the different time zones of the participants. It talks about data security, confidentiality, and the very important need for test runs and contingency plans, because I think, as all of us know, technology does sometimes fail us. All of these issues are not only important to ensuring a smooth hearing, but they are critical to help avoid due process challenges to the award upon enforcement. The guide also includes appendices to help parties and tribunals select the right remote hearing platform to help draft an effective and comprehensive procedural order concerning remote hearings, and also to abide by the appropriate hearing etiquette in light of the virtual format. These issues and more will be discussed by our panelists, including SIAC Court Member John Bong, in the next panel discussion, the first panel discussion, which talks about the do's and don'ts of virtual and hybrid hearings. The SIAC guide, like the Seoul Protocol on video conferencing in international arbitration, is one of many resources available to parties as we navigate the new normal and this digital age. As the arbitration community has risen to the challenge of adapting to COVID-19, we have discovered that challenges also often bring opportunities. The COVID situation has sharpened the focus on the factors that make Singapore an attractive arbitral seat and dispute resolution hub. Singapore provides an ecosystem that guarantees neutrality, independence, integrity, stability, predictability, and the rule of law. Singapore constantly implements legal reforms to improve its international arbitration framework and ensure that it keeps pace with developments in arbitration practice. For example, Singapore was the first jurisdiction to amend its Arbitration Act to make emergency arbitrator awards enforceable in both Singapore-seated arbitrations and arbitrations seated outside of Singapore. The legislator also recently updated Singapore's arbitration legislation to align with global best practices and to be responsive to evolving user needs. Singapore also has a world-class judiciary that continues to be very supportive of international arbitration. During our second panel this evening, SIAC board member Chung Ezeong will elaborate on the Singapore Judiciary's approach to international arbitration. And along with our other panelists, they will discuss the factors that make Singapore and SIAC an attractive seat and arbitral institution, particularly for Japanese parties. In some ways, the pandemic has had a leveling effect in the international arbitration community. Parties can be anywhere in the world and participate in a remote hearing. This reduces the extensive costs associated with in-person hearings, including the significant environmental impact of travel and hard copy hearing bundles. Capacity building has also gotten significantly more diverse. Speakers need not travel to speak at seminars like this one. This opens the door for younger and more diverse members of the community to have access to speaking opportunities and build their professional networks. Likewise, practitioners and aspiring practitioners from all over the world can participate in training programs and seminars with only an internet connection. At SIAC, we have held over 50 virtual events since April, including the first ever virtual edition of our flagship event, the SIAC Congress. We've also had a handful of virtual training programs like the SIAC Academy and the SIAC module. To give you one example, the SIAC Northeast Asia Academy, which was held in September, virtually in September, we had participants from as far as the Bahamas, Barbados, and Austria, and they were participating in mock hearings and other exercises along with participants from Japan, Korea, and other Asian jurisdictions. It's really a testament to the adaptability of international arbitration that in the face of unprecedented disruptions to not only international business, but to our very way of life, that we've been able to connect throughout the pandemic and hold this hybrid event featuring speakers from Japan, Singapore, Korea, Australia, and the UK. Although 2020 has brought significant challenges to the arbitration community, the core tenets of international arbitration remain. At SIAC, we strive to provide users with access to a dispute resolution mechanism that is efficient and flexible, fair, final, enforceable, confidential, party-driven. This has taken on particular importance as the international business community works to mitigate the impact of COVID-19, in part by quickly resolving disputes that rise out of the pandemic. In fact, SIAC has been busier than ever. Just last week, we announced a record caseload for the year 2020. We crossed the 1,000 case threshold for the first time ever, after consistently having over 400 new cases a year for the past 3 years. We also officially launched SIAC Americas and opened a representative office in New York. This is our first representative office outside Asia. We are also working on our rules revision, and we are consulting widely with users and stakeholders around the world. Japanese parties are a valued top foreign users of SIAC, and we look forward to continuing to work with our stakeholders in Japan as we all navigate this new normal going into 2021. We welcome your feedback and your suggestions on how SIAC can further improve our services and our rules to enhance your user experience. On that note, I will wrap up and wish everybody a productive seminar. I will be back to moderate the second panel, so I will not say goodbye yet. I do note that we are a bit ahead of schedule, so I think we'll take about a 9-minute break, and then we will return at 5:30 with our first panel discussion on the do's and don'ts of virtual and hybrid hearings. Thank you, and Eriko, over to you.
Thank you, Michelle, for that interesting perspective on arbitrating during the pandemic. If I may now introduce the speakers for the first panel session, titled Do's and Don'ts of Virtual and Hybrid Hearings. Moderating the session is Mr. Tony Andriostis, a partner at Queen Emanuel, Urquhart and Sullivan LLP. The panelists are Mr. John P. Ban, member of the SIAC Court of Arbitration and head of international arbitration at Bae Kim and Lee LLC. Mr. Chao Shen Yu, head of litigation and dispute resolution at One Partnership LLP. Mr. Dashini Prasad, member of the YSIAC Committee and Senior Associate at Wilmer Carter Pickering Hell and Door LLP, and Mr. Tomohiro Tatino, Senior Associate at Impex Operations Australia.
Okay, thank you very much for that, Eriko. As was just said, my name is Tony Andriostis. I'm a partner at Queen Emanuel, Urquhart and Sullivan. Also a lecturer at Keio Law School and adjunct professor at Temple Law School. And I'm on the advisory committee of the JIDRC. And that last title is one of the reasons I'm so delighted to be moderating this session right now, because as was mentioned by Professor Hayakawa earlier, I'm actually here at the JIDRC, and I think it's important that Professor Hayakawa and I are here to, first off, to show the hybrid aspect of the facilities, but also to show the world that Japan is open for business and that the JIDRC is open for business. Quite frankly, even at the heart of the pandemic, Japan was still functioning financially and commercially. They took a lot of needed policies and rules, and they complied to them, and things are going pretty well here now. And reflecting the words of Michelle's, I pray that everybody watching, that they are safe and their families are safe. And it's a tough time right now with the pandemic. And it was reassuring to see how quickly not just Japanese business and industry, but worldwide commerce shifted to adjust for this pandemic, and to see how work from home and remote work became a standard for most major corporations. Now, though we saw some changes amongst the judiciaries and court systems throughout the world to accommodate this pandemic and to accommodate the new reality, this was actually a time for arbitration to shine. This is a time where the flexibility of arbitration really came front and center. And that's one of the reasons I'm very grateful to both SIAC and JIDRC for putting forth this discussion today, because we now see how the flexibility of arbitration can allow for the continuation of dispute resolution, no matter what the situation is with the pandemic. So Eriko kindly introduced the panelists, and they know themselves a lot better than I do. So I like to ask the panelists, when I call your name, if you could just pipe in and tell us a little bit about yourself and why you're well suited to discuss the point of discussion, which is the do's and don'ts of virtual and hybrid hearings. So I'd like to start with Mr. John P. Bang. So John, please, the microphone's yours.
Thank you, Tony. I'd like to thank Tony for the general introduction. And as you said, my name is John Bang. I'm based in Seoul, and I'm the founder and head of Bae Kim Lee's International Arbitration and Litigation Practice Group, and a member of the SIAC Court. I have to admit, sitting in my own office, looking into a camera and talking about myself is now how I imagine I would be introducing myself at conferences this year. But as times change, we must adapt. And as much as it pains me not to be in Tokyo today with all our friends, I'm very grateful to have the opportunity to speak to everybody here. In Seoul, our practice is made up of approximately 25 lawyers from different parts of the world, and is focused on a wide variety of large international cases. Specifically, we have extensive experience in investor state cases, complex construction cases, and of course, commercial arbitrations. I think I'm hearing some sound from somebody. They may want to mute, or I'll just continue to speak over them. But we also focus on outbound cross-border litigation cases, which essentially is assisting Korean clients in national court litigation abroad, whether it be civil or common law jurisdictions. I look forward to listening to the other panelists and hoping that I don't bore them too much when I speak. And thank you very much. And I will pass it on to the next person.
Well, thanks a lot for that, John. And I put John first to stress the New York, New Jersey accent, the Northeast United States accent that we both share. So thanks for letting me do that, John. And now we'll move on to Sean Yu. Please, Sean, the microphone's yours.
Thank you, Tony, and good afternoon to everyone. Thanks again to SIAC and to JIDRC for the kind invitation to speak at this. It's always a difficult act to be, to follow John Bang, a more illustrious profile and international arbitration lawyer. So I will try my best to keep up with him, as I always do. I head up the litigation and dispute practice group at Wong Partnership in Singapore. It is a practice group that comprises of about more than 160 fee earners across various practice areas. My work is mainly as counsel. I do a fair bit of financial regulatory work as well, which is a fairly large emphasis of the work that I do. But I also sit as arbitrator as well. And ever since the pandemic unleashed itself upon us, I've had the privilege of being counsel in fully virtual and hybrid hearings, and also sitting as arbitrator in fully virtual and hybrid hearings as well. And I'm more than happy to share some of my thoughts and insights on the issues which we'll be speaking about this afternoon. Maybe a little bit more about myself. I also act as a racing steward at the Singapore Turf Club. So horse racing is a side interest of mine and a side extrajudicial work as well. And in fact, many of the inquiries that I sit on have been fairly hybrid as well. And that's a different perspective that I can share. Thank you.
I did not expect a horse racing tie-in, Sean, so I thank you for that. Now we move on to London, actually, where we have Ms. Darshini Prasad. Ms. Prasad, the microphone is yours.
Thank you so much, Tony. I feel like, having said what he said, Sean, I'm going to have to say you and John have raised the bar even higher for me. I'm not sure I can really quite follow on from either of your profiles and background, but just very briefly, as Tony mentioned, I'm based in London. So good morning to those of you in this part of the world. Good afternoon to everybody else in Asia. I'm currently with the arbitration practice of WilmerHale in London. The head of our practice is Gary Bourne, who's also the president of the SIAC court. And in that context, as well as in my capacity as a SIAC committee member, I've had the opportunity to work quite closely with SIAC. And prior to joining Wilmer, I did practice in Singapore as well. So that has been quite a great experience to have that cross-jurisdictional exposure. In terms of Japan, quite interestingly, I've had, notwithstanding the background that I seem to have, I've done a fair number of Japanese disputes and Japanese law disputes as well. And interestingly, Professor Hayakawa is one of our experts. I'm not sure he recognized that I was going to be on the panel, but he is actually sitting as one of my experts on a case, which was due to go for a hybrid hearing right now. Actually, we would have been in the hearing as of now, but that had to be postponed for certain reasons. But in the run up to that, we had a good deal of exposure on how to plan these hearings. And so that's hopefully something I can share over the course of this session as well. So looking forward to this panel.
Wonderful. Thank you very much. And I'll use the cliche, last but not least, we have Mr. Tomohiro Tatino, who is joining us from Australia, right?
Correct, Tony. Thank you. Good evening, everyone. In fact, I think I have to confess first, I am supposed to have the New Jersey accent as well. So I'm supposed to be one of those New Jersey members. But unfortunately, it appears that I lost that virtue, so to speak, being contaminated in this Australian environment. I think I'm kind of contaminated by this Australian accent thing these days. But nonetheless, I'm supposed to be a member of the New Jersey accent group, so to speak. Now, having said that, I am currently in-house counsel of Impex Corporation, which is a Japanese oil and gas upstream development company. I'm currently seconded to a LNG project company now, so in Australia. So that is the reason why I am based in Australia, actually Perth, which is 39 degrees at the moment. Before going in-house, I was practicing arbitration as a Japan, New York qualified lawyer. So I did have some background practicing arbitration in that sense. Now, being on the client side, it is like any other oil and gas project. I think any oil and gas project lawyers would admit, I mean, we do have some disputes. So I do really look forward to understanding the best practices of remote hearing, which is a trend these days, from my colleague panelists. So that's all I had, Tony. Back to you.
That's wonderful. And you are more than welcome to the Northeast United States Accent Club. But just to qualify, I do speak the Queen's English. And by Queen's English, I mean Queens, New York. So it's not New Jersey. So just wanted to qualify that. So now we'll move on for a bit of housekeeping. And I'll just say that all of you will have on the bottom of your screen a chat function. If you have any questions, feel free. I mean, and I'm speaking to the audience now. Feel free to send them via the chat function. And that way I'll be looking at them, maybe combining them. So I'd like this to be as interactive as possible so that we can get the most out of this exchange. So before we go to audience questions, I have a few questions I'd like to ask the panelists themselves. So I'd like to get back to John and said, John, why don't you frame this for us? What exactly is a hybrid virtual hearing? And what are the important do's for planning a hybrid virtual hearing? So I hand the microphone back to you, John, please.
Thank you, Tony. I want to also extend my thanks to the SIAC and JIDRC for organizing this excellent discussion. I must admit that personally, I am a proponent of the view that in-person hearings are more effective than virtual hearings, particularly with respect to lengthy evidentiary hearings. I actually made the case for this position at the SIAC Congress this year, which is available on YouTube if anyone wants to check that out. However, I understand that the pandemic has made in-person hearings impossible for many cases in the last 7 months. and will continue impact cases with hearings scheduled in 2021. To that end, we must endeavor to develop practices that ensure that virtual hearings best serve the parties. So, as to the first question, in the first few months of the pandemic, the world was truly paralyzed. Most cities were completely shut down. Offices were not working at all. Whatever hearings had happened then, in a way, were fully virtual. As hearing facilities and offices were shut down, almost everyone appeared from their own homes, through their own computers, from different locations. However, this situation is neither ideal nor desirable for virtual hearings. Since that time, governments and businesses have responded. The world has moved to a new normal, one with temperature checks and masks, but one where offices and hearing facilities are available with precautions, even if international travel is not. This is currently the situation in many parts of the world, and definitely in major Asian cities, including Singapore, Tokyo, and Seoul. Therefore, the hearings we often now participate in can be termed as hybrid virtual hearings. More often than not, counsel teams will congregate in one facility, either at hearing centers or their offices. Wherever possible, arbitrators too will attempt to sit in the same room. This situation has several advantages, which I will get to in a moment. The aim of the parties is not to create the most high-tech setting, but working to ensure what can best simulate the experience of an in-person hearing. And for that purpose, a hybrid virtual hearing is far more appropriate. So there are several variables that one must take into account when planning for a hybrid hearing. And so let me go through and answer the second question and discuss some of the do's for planning a hybrid virtual hearing. First, do focus on the logistical questions as people are tuning in from different parts of the world and often from different time zones. It is likely that the hearing time available to the parties will be lesser than compared to what they're used to at in-person hearings. This, coupled with the low attention spans in the virtual medium when compared to in-person hearings, means that each second is very precious. Discuss logistical concerns with the other side and the tribunal, and make contingency plans, as Michelle noted. Don't be caught off guard. Second, if possible, try and ensure that the tribunal is in one room next to each other and appears in front of the parties as a panel. This is often not possible if the tribunal is situated in different countries with travel bans. But if at all possible, this is very helpful for a hybrid virtual hearing. It allows the tribunal to consult at all times without going into separate breakout rooms, and is useful, particularly deciding on contentious objections and other procedural matters, where the presiding arbitrator can easily consult with his or her co-arbitrators without interrupting the hearing. Otherwise, the tribunal going to breakout rooms to discuss each time is not only an inefficient utilization of time, it also harms the flow of the hearing. At the same time, the tribunal being together allows you to better gauge their reaction when compared to a situation where they are seated in different rooms and can't really consult as the hearing goes on. Do and try to ensure that counsel teams are logging in from one venue instead of several offices. This ensures that the lowest amount of time is spent on facilitating conversations between members of the same side, as well as ensuring the highest level of teamwork. In terms of how you structure a room, I would try to have two large screens, one for the tribunal and the main speakers, one for the documents. At the same time, keep one or two laptops close to you so you can refer to your notes and have live note transcription. Virtual hearings will be equally, if not more stressful than in-person hearings, and simulating its environment by having your team and all the relevant documents next to you can be very beneficial. 4, do and try and ensure that witnesses give testimony from a natural venue. This could be a room at a law office or a room at an institutional's premises, so that at least one representative from both sides can be present to ensure that there are no questions about the integrity of the testimony. The representatives can also assist the witness with the hard copies of hearing bundles, and also which also assists the witness in facilitating the speed of the process. Fifth, ensure that you can get an experienced operator for the platform that you use for the virtual hearing. Institutions are well as major service providers, both operators who are experienced at conducting virtual hearings. Their task is vital. If they are competent and can lead the parties to the breakout rooms at the right time and avoid any technical lags. It is vitally important to speak to the operator and do a dry run to test out all the features and to be comfortable with how the system works. As previously mentioned, attention spans and hearing times are both low. Do pick an operator who has experience with both arbitration and virtual hearings. I could go on and discuss various other things, but because of the time, I would lastly say that do try to ensure that the parties discuss and agree to a virtual hearing protocol, the details of which my friend and colleague Sean will eloquently address momentarily. Thank you very much.
Thanks a lot for that, John, and thank you also for reading my mind and projecting what my next question will be. My next question will be to Sean, who will, as John declared, eloquently described what these virtual hearing protocols are and why they're important. I think Michelle early on had mentioned, for example, the SIAC guide. I know that there's also the SOL protocols in place. So if you could tell us a little bit something about that, that'd be great, Sean, please.
Yeah. Many of the points which John raised about hybrid hearings will apply to fully virtual hearings. And by fully virtual hearings, I would refer to hearings where all of the participants are dialing to hearing by video conference from different locations. No one is together. And that is the reality in which we find ourselves in right now, where many of us have to conduct hearings, from different locations and do not have the luxury of being in the same room at all. So, the pandemic has obviously transformed quite radically, how we work. And to be frank, fully virtual hearings, are effectively the only way to progress proceedings in many parts of the world. Michelle had referred to earlier to the initiative taken, I think in April this year by SIAC and other international institutions, where they've come together, issued a statement encouraging parties to consider potential approaches to address the impact of the pandemic. And since then, many institutions have started to supplement, refresh the rules by publishing guidelines on virtual hearings. And the idea really is to provide a platform, for hearings to proceed without delay and without disruption. These efforts from the institutions were in fact replicated by several national courts, where in some countries legislation was passed to allow for evidence to be taken remotely with more ease. I think the reality is that it's much easier to take evidence by video conference link international arbitrations than in some national court proceedings. There are certain restrictions in certain jurisdictions. I just wanted to share very quickly the experience that I had in the Singapore High Court. The Singapore High Court was shut down for a while in terms of the conduct of trials, but it resumed business in early July 2020. And I had the privilege of acting as counsel in one of the first such fully virtual court trials in early of July in 2020. By then, the Singapore Supreme Court had issued a guideline covering various technology issues for virtual hearings, but we were really still wading into relatively uncharted territory. The trial judge in my matter was, however, extremely patient. He was very keen to conduct the fully virtual trial, in the best way possible, and extremely flexible in ensuring that the trial process was not impeded. Not a luxury that perhaps some of us might have with some arbitrators. In the end, it was a successful pioneer effort and we even managed to conduct a witness conferencing of expert witnesses in that trial. But what we didn't have, and we all now know months later, is something which we would consider to be absolutely necessary, and that is to have a protocol in place to govern the conduct of the virtual hearing. I think many of you will be familiar with the SOAP protocol, which Tony just mentioned, that was introduced in 2018 by a group led by Kevin Kim, that was drafted to assist on dealing with all potential issues in taking evidence by video conference. They had the foresight of identifying several core issues, including due process, confidentiality, and technology, amongst other things. Those main principles have now become more relevant 2 years later. Michelle also referred to the release in August 2020 by the SIAC of its guide entitled Taking Your Arbitration Remote. It provides important recommendations and a checklist of aspects to consider when planning a virtual hearing. I do consider this to be an essential roadmap to a discussion which tribunals and counsel need to engage on for the purposes of putting together this virtual hearing protocol. Appendix B of the guide in particular is an extremely important checklist of the matters to be considered for inclusion in the virtual hearing procedure order and the protocol. What is the protocol? The protocol basically sets forth certain guides, rules, and provides a structure as to how the virtual hearing should be shaped, the form that it takes, and there are many matters which need to be discussed, thought about, considered, and included in the protocol. And the SIAC guide essentially provides, as I said, the roadmap for that. And I must say that every set of proceedings would have its own unique aspects, and the protocol that needs to be developed has to be carefully considered, and arbitrators need to make provision for unique aspects of the case. There is, I'm afraid, no one-size-fits-all protocol that it can easily be copied, and it will be remiss of arbitrators not to spend time carefully developing the right protocol for the case before them. I don't propose to discuss all the various aspects which need to find its way into the protocol. I think that by itself, can be occupy the time for an entire seminar. But one of the things that I thought I can mention by way of illustration as to why a protocol is important, and is really in relation to what one can provide protocol in relation to witness testimony. A common reason given by respondent parties who wish to delay the conduct of a hearing is to claim concerns about the integrity of evidence being presented by a witness remotely and about the potential risk of witness coaching. While I must say that there's no 100% safeguard against this in the context of a remote hearing or virtual hearing, carefully drafted protocol will go some way to address these concerns. A good starting point is Article 3.1 of the SOAP principles, which was mentioned earlier, that prescribes that the identities of any persons present in the same room as the witness giving evidence, that would have to be disclosed, and only specific persons can be present with the permission of the tribunal. I will comment on item, I think, 38 in the Appendix B of the SIAC guide. It provides 4 useful aspects which I would commend for inclusion. The first, I think, states that there should be a direction that the witness gives evidence from an empty table, so nothing there except for the hearing bundle, no personal items including phones. The second suggested guideline is to require the witness to remain within the camera frame at all time. Thirdly, how do you manage breaks for the witnesses or when they need to sort of like move off camera? Fourthly, I think there's a suggestion that you have the witness provide a 360-degree view of the room so that, everyone knows, whether there's someone else in the same room as well, and to do so at the start before the testimony is given or at certain intervals. I think there are many more that can be included in the protocol. Perhaps I can suggest some for now. And one suggestion that I think has worked well and has found its way to the protocol that I drafted recently was to provide for a camera at the rear of the witness, which provides a view of the front so that you can see what the witness is doing. I think a second tip that I can suggest is no virtual backgrounds, because with virtual backgrounds, as you can tell, you can't really see who's behind me. But I think, the most, interesting, aspect that can be included in the protocol is this, and that is to provide for the attendance of an invigilator. While it does add up to the cost, but that's probably the most effective way of addressing any potential tampering. You can have someone present in that room from the other side, making sure that there is no outside interference. I think the final point that I would like to make now is that virtual hearings will be a hallmark of our dispute resolution landscape until the world reverts back to normalcy. And until then, a good protocol is an integral part of this new normal. Thanks, Tony.
Thank you, Sean, and thank you also for making my job easier, because you addressed one of the questions we had from our audience. Our audience threw out a question related to transparency of witnesses. And it's interesting, this also ties in with, some of you may be aware, in the States, there's a lot of controversy about taking the bar exam remotely. And a lot of what you've just discussed was raised by the various bar associations, where you put the camera and the like. So this is something being addressed by many bar associations throughout the world. And thank you for addressing that as well, Sean. So I'd like to move on to Darshini Prasad in London. So Darshini, I might have a more specific question for you, and it's also along the lines of how we deal with the witnesses in this type of virtual hearing. So what are the due process considerations that arise in a virtual hearing, different from a regular, I shouldn't say regular, but a live hearing? And relatedly, are there circumstances in which a virtual hearing might violate a party's right to be heard? So, Darshini, please.
Thanks, Tony. I think those questions are, in some senses, two sides of the same coin. So hopefully if I address one, I'll address both. I think the due process aspect of remote hearings in some ways was maybe more of a debated concern in the early parts of the pandemic, when it wasn't quite clear how these proceedings would play out when you're talking about large complex cases. Of course, remote hearings have been a feature of arbitration for quite a while, but I think the scale at which they're being used and the variety of proceedings in which they're being used is quite different. And so that was much more of a concern at the start. I think now, through experience, including some of the very helpful points Sean's made that we've gathered over the course of the past few months, a lot of those concerns have whittled away. But of course, it's important to always think about the due process issues at the time you're debating, A, whether to have a remote hearing, and B, if so, how to do so. And I think, not really, I think something that needs to be mentioned, but this is quite an important consideration because, as we all know, a failure to comply with the party's due process rights, whether it's the right to be heard, an opportunity to present your case, or whether it's the right to be treated equally, would provide a basis to either set aside an award or to challenge its enforcement in jurisdictions outside of the seat. So it is quite important to think about these. I think a lot of the due process issues that you might typically think of are these days addressed in the context of protocols that parties try to agree on at the outset. And one of the big issues, as Sean mentioned, is how you deal with the integrity of the evidence that witnesses are giving. I'm not going to go over that because Sean did such a great job in setting out what the issues are and also how to address them. I do completely agree with him that the best way to deal with that issue is probably to have a neutral observer present in the vicinity of the proceedings. That's not, of course, always possible, failing which, and some of the other ideas that Sean suggested are points that people have raised and have tested, so having a 360-degree camera. I quite like the suggestion of having a camera at the back. I'm not sure I've heard that before, But I think that's obviously one that would give you an insight into what it is that the witness itself sees. So that's useful. If I was the witness, I would probably be slightly unnerved by the fact that I have a camera behind me, but it is what it is. But there are the due process concerns to think about. And I can draw on some of these in the context of the case I mentioned that I was supposed to be having a hearing for right now. A big issue you often hear, and this goes more to whether the parties are being treated equally, is factors like time zones. So this case that I was supposed to be involved in, it was for a Japanese, it involved a Japanese party. So of course we had counsel and clients and witnesses based in Japan. We had an arbitrator based in Hong Kong. We had the chair of the tribunal based in Europe. Our client was based in Europe. We had witnesses based there. As counsel, we were in London. The other side's lead counsel was in the East Coast of the US, and we had witnesses in the West Coast. So you can imagine it was a logistical nightmare to think about how to organize this. And some of the considerations that were addressed was, if you have such a broad spectrum of time, what is the appropriate time frame to have the hearing? And there were obviously risks about when you would cross-examine witnesses. It has to be at a time when they're not going to be unduly tired. So it couldn't be too early or too late at night. That meant we had to break up certain cross-examinations just to make sure that witnesses weren't being taxed. There was also a question of whether counsel who is in for the other side based on the East Coast, whether they would be able to seek instructions from the client, because if the hearing was going on in ungodly hours in Japan, they obviously wouldn't have their client representative able to participate. So these are all kind of due process considerations to think about, time zone issues, whether you are able to get instructions properly. Another question that does come up is actually how the witness is given access to evidence. The hearing bundle, as Sean mentioned, is one thing that you can obviously keep in front of the witness. But there's now, I think, quite a well-known Australian case this was pre-pandemic, but I think the lessons are quite useful. One of the challenges that was raised to an award was on the basis that the fact witness that was giving evidence did not have access to the materials or properly have access to the materials in which he was being cross-examined. For various reasons, the Australian court there declined to set aside the award, but it gives you a flavor of how these issues can arise. So it's important to kind of make sure in advance that the witnesses have proper access to the materials they're being cross-examined on. And so we talk a lot about the things that you can do at the outset, but I should also briefly mention that the best laid plans are made to be destroyed. And so oftentimes, especially when you're talking about virtual hearings, you could end up with various technical disruptions. And one question that arises is how tribunals have to deal with these. If you have a contingency plan, it's obviously great, but sometimes it just means that the proceedings need to be temporarily suspended until connections are reestablished. That happened in another hearing of mine recently where lead counsel for the other side just vanished into the ether of the internet and didn't reappear for a good 30 minutes. But you then had a quite illustrious tribunal waiting for 30 minutes, as well as about 20 people on the call, all waiting patiently, trying to make awkward small talk. But I think, those are just the scenarios you have to deal with. And one last point I should make, and this goes, I think, to what John had discussed in his presentation, which was about hybrid hearings. I think it's of course, to the extent you can do a hybrid hearing, it's always a good halfway house to have. But there's also a question as to whether a hybrid hearing could raise due process concerns. And I think the SIAC guidelines advocate for a slightly all or nothing approach, in that they say if either party isn't able to attend, it's probably best that the entire thing be done remotely. I think there's a question of which parts of it you're talking about. If counsel is all able to attend physically, then maybe that can be done hybrid. But if either side's counsel isn't able to attend or lead counsel isn't able to attend, that might be a good reason to switch to having it fully remotely, even if certain team members are in the same place, but the hearing as a whole is conducted virtually, so the tribunal isn't in the same space as any of the legal team. But I think that hopefully covers most of the big due process concerns that are likely to arise, and that parties should think about when they're planning their hearings.
Yeah, Darshini covers it so well, in fact, that I have to initiate the cliche that no good deed will go unpunished by giving you a follow-up question, if you don't mind. So the way you described it, all these kind of risks that are seeping into these hearings, are there any set aside or enforcement risks that could come up from this? Because, you know, we look at arbitration as the flexibility, but in light of the trickiness and the newness of the expansion of these types of hearings, are there any set aside enforcement risks we should be looking at?
I think there's definitely enforcement risks to be thinking about, but I think what we could probably, in some senses, get off the table, off the bat, is the idea that a remote hearing is per se problematic, or a remote hearing per se infringes a party's right to be heard. I think arguments to that effect have been raised. I think the force of those arguments have definitely whittled away over the course of the pandemic. It's quite hard, I think, to take that position now. But in any case, even pre-pandemic, as I said, remote hearings have been a feature of not just arbitral proceedings, but court proceedings as well. So the idea that somehow doing things in a remote setting prevents you from presenting your case, I think, is a difficult position to take today. But there are, tying back to my previous response, depending on how proceedings are structured and depending on how the proceedings are actually conducted, there could be due process risks. And this could relate to things, as in the Australian case that I mentioned, how witness evidence is taken, the integrity of the evidence that's given, time zone issues. Some of this can be addressed at the outset, at the time that you're drafting a protocol. Parties, could be asked to be, in the protocol itself, you could have a consent provision or a waiver provision in the end, where the parties sign on to say that, they waive any objections of a due process, or they agree that there are no due process concerns or other bases to challenge an award if the protocol is complied with. But of course, to the extent that things happen in the proceedings, it is something that the tribunal has to be quite alive to and decide how to manage the proceedings and exercise its procedural discretion. And that goes to the due process point, which I think is quite well addressed. There's a different question, which I think we almost jump ahead to sometimes now because of how well-established remote hearings are. There is a question as to whether tribunals have the authority to grant, to order remote proceedings be taken place. And again, I think this question seems a little bit moot at the stage at which we're at. It was slightly more debated in the past, but I think now it's broadly acknowledged that tribunals have the discretion, but it's still worth, I think, keeping an eye on whether, particularly in a circumstance where one or, more unusually, both parties object to a remote hearing, it's worth keeping an eye on the applicable mandatory laws, the applicable arbitral rules, and also the parties' arbitration agreement. I think I haven't at least seen any arbitral laws that would prevent a remote hearing or arbitral rules. There was some uncertainty in the ICC rules about whether you'd have to have an in-person hearing, meaning a physically in-person hearing, but their COVID guidance, I think, has clarified that that's not really an issue. And I think the last thing to maybe look at is the parties' arbitration agreement or any other agreement that they may have. If that, of course, fetters the ability to have remote hearings, then it's something the tribunal should consider if it decides to override. And whether you can will probably depend on the terms of the agreement and the circumstances, but that's obviously something to look at as well.
Okay, thank you very much for that. I just want to again say to the audience that please do feel free to use the Q&A feature on the lower part of the of Zoom to ask any question you may have. But now I'd like to go, and this is literally a last and but not least situation, because Tomohiro is client side, and for us practitioners, we know that they're the ones that really, really count and that really, really matter. So I'm addressing you, Tomohiro, now. First off, what are the benefits of these kind of virtual hearings from a client perspective? So give me the pros and cons of the virtual hearings in general. But I think what we, and by we I mean the vast majority of the audience and definitely the entire panel, really want to know is, what does the client think about all this?
Right. Tony, before I go to that, I did have a question which kind of relates to cons of arbitration from client perspective. I know we only have 17 minutes, so I just want to jump to the question I had to my colleague panelists, because I thought this will be my opportunity to get free advice, to be honest. Joking, putting aside that issue. So the cons really are, I can talk to later, depending on the time left. But as a client, we do wonder when we should really be objecting to virtual hearing. When, of course, I mean, Darcini said, I mean, it appears that the tribunal does have the discretion to decide whether to have virtual hearing or not. But putting aside that issue, I mean, as we all know, tribunals will ask opinions from the parties as to whether they would agree to have do certain hearing on a virtual or remote basis. Now, under what kind of circumstances should the parties really feel strong that we should not be agreeing to a virtual hearing? And I have in mind, like, you know, perhaps procedural hearing is not a big deal, but I don't know, what I have in mind is somewhat controversial cross-examination or expert examination, something like that. But I'm just wondering, from a client perspective, what are the situations where clients should really stand up and say, look, we don't want to do this on a virtual basis?
Okay, let's do
I
it.
can answer.
Okay, John, you volunteered. John, why don't we do it this way? Why don't we have Tomohiro first discuss the pros, and then you'll jump in with an answer to that? How does that sound? Okay, so Tomohiro, please deal with your question first. Thank you.
Okay, got it. I guess in a nutshell, I was about to discuss the pros and cons in general of remote hearing or virtual hearings, but I think a lot of point was really covered by John, Sean, and Darcini, really, to be honest. I was about to talk about the coaching issue, which appears very concerning from client perspective. You know, are the witnesses really speaking about their real memory, or are the experts really not being guided by someone when they're speaking? But I guess that point was really covered by Sean. I mean, yes, it'll be nice to have someone neutral in the room, but in this era, it is very difficult, at least in the proceedings I've experienced. I mean, it was really a full virtual hearing, so there wasn't really anyone who can just jump into the room. So, I mean, the camera, 360-degree camera, 2 camera, et cetera, I suppose is the answer to that. And that's the best practice so far, it appears. Another thing from client perspective is really about confidentiality. Yes, the virtual hearing protocols tend to have, attendees list and the like, but I mean, you never know who is behind the camera. And it's sometimes really concerning from client perspective, who is really listening to this hearing. When the stake is really high and something really confidential, I mean, we do get concerned. And, yes, of course, the hearing transcripts can be circulated, but nonetheless, it is concerning when, actual hearing, when we don't really know who is really behind the cameras. Another one I was about to raise was time difference issues. Now, Darcini, I think you have the beauty of being in the center of the world, so I don't think time issue is really a problem for you. But, being in Australia, Japan, Korea, or perhaps in Singapore, because we are in the same time zone, sometimes it is very difficult, really, from client perspective, to even persuade a witness, someone from your company to say, okay, you got to stay up from 1 a.m. to 5 a.m. to testify. And of course, they would not smile when I asked them to do that. So something, concerning from client perspective, time difference is one really thing. I mean, when we were traveling there, a lot of witnesses was happy to travel to London or Singapore or whatever. But if it's virtual, they're not really happy staying up from 1 a.m. to 5 a.m. and whatever. And Lastly, I was going to touch on as the cons, really, the technical issues. It is, I think, the Murphy's Law. I mean, the web conference system or the live transcripts will go down when we're having the most important conversations. That's kind of Murphy's Law. I think I've experienced that several times. So again, those technical issues are, I think, still out there, although I am fully aware that all the protocols try to address that. Try to address that, but in practice, I think it is a concern still. Now, the benefits, I think, of virtual hearing is really, and that, the fact that we can have these hearings on a remote basis during the pandemic, that was once a significant benefit for a client. I think the accelerated hearing schedule was another benefit for a client as well, which kind of ties into my other point, which is cost issue. So, I mean, previously, I think it was because we were all traveling, we wanted to have 20 consecutive days of hearings, whatever. But nowadays, I mean, it appears everyone are more flexible. We can have 7 days hearing, 3 days go off, do another hearing, and then 7 days, continue on with the latter half of the hearing. Those things, I think, are actually happening. And that has proven to be really beneficial for clients as well, because yes, the cost associated with arbitration, especially in a big case, is not minimal at all. I must also say, from cost perspective, the fact that we do not have to pay accommodation costs or travel costs, although it is not big, but I mean, that has, some attraction from client perspective. I mean, 20 days hearing with 10 external legal counsels, like 10 to 20 witnesses and 10 experts is not really cheap for client. So again, that has been beneficial from client perspective. And finally, and this wasn't really what I was expecting before the pandemic, but what I found after while we were doing these kind of virtual hearings during the pandemic is really this. I really didn't know that executive or management is interested really in attending hearings. So when they came to realize that they do not have to travel to attend hearings, or they can just go in and out any hearings, it was surprising, but a lot of management personnel said they would like to attend the hearing, they would like to observe the hearing. So for instance, I mean, they wouldn't really go into the nitty-gritties of cross-examination and the like, but certainly they would like to be there for the opening. And some people say they want to be there for the closing. So that was really surprising, which I think is a very positive, at least from in-house counsel perspective, for two reasons. One, it makes our life really easy to report to them. I mean, if they can observe how the case was argued, it makes the reporting much easier, to be honest. And they have greater understanding of the case, way better than what you would really imagine, just briefing them 30 minutes after the hearing or something like that. The second thing really was, I mean, those kind of understanding kind of reflects really in the discussions that management have. I mean, for way forward. And of course, if they want to settle, I mean, what was argued in the hearing really is reflected in that when considering whether to settle or not. So again, reporting is easier, and for the company to decide way forward, the decision-making becomes much easier. Is somewhat unexpected, really, kind of virtue of virtual hearing that I've found these days. So I kind of rushed my points, but again, I think I covered everything I want to say, Tony.
Yeah, you did, Tomohiro, and thanks so much again. It's very critical for us as practitioners to hear what the client wants, and it also gave John some time to think through that question. So, John, Tomohiro, let me know if I'm not asking this right, but what you wanted to know is when you would advise, when we as practitioners would advise our clients to object to a virtual hearing. Is that right, Tomohiro?
Yes, that is correct, Tony. Thank you.
John, the microphone's yours.
Thank you, Tony. I think, there's obviously competing interests. Claimants want to go as fast as possible. Respondents, in most occasions, do not. And arbitral tribunals, if they're paid on an ad valorem basis, probably would want to have the case heard faster than later. But I think, in my experience, we've had, especially in the early part of the pandemic, we've made certain objections. And I think during the early part of the pandemic, you had some accommodating years from tribunals for cases where there is it's a complex evidentiary hearing with, where you were, thinking about maybe 2-3 weeks. You have 15 different witnesses. You have 5 to 10 experts. And what you would do is you would raise what Darshini discussed about due process concerns, that you would not get a fair and efficient, you wouldn't be able to present your case in a proper manner because witnesses that you will have to present will be having to wake up at 2-3 in the morning. Witnesses will be testifying from home. You talk about the integrity of the examination. You talk about having the need to have a forensic type of cross-examination where you need physical hearing, bundles to go through a 5-hour cross-examination of various different factual points that are at the heart of the dispute. I mean, there's a lot of different arguments that you can make, and I think those arguments are, better. They're more responsive from the tribunal if it is a complex, long evidentiary hearing. You could also ask a tribunal to maybe break up the hearings, as was mentioned before. Maybe have 1 week here and another week there, and then another week several months later, so that at least you can fall back to that option. But if your main argument of postponing the hearing until an in-person hearing is possible. The problem these days is that after 7-8 months, and we just had a hearing, a hybrid virtual hearing 2 weeks ago, where both parties said that we wanted to postpone the hearing because we both wanted in-person hearing. And the tribunal essentially told the parties, no, we want to have the hearing, and let's try to have a hybrid virtual hearing. And so, I don't think the objections these days are going to be accommodating as much as it was before. But I still believe, and as I said at the beginning, I'm a proponent that for hearings where you have, say, construction case, 20 claims, you have, 8 different witnesses on various different claims. It's very difficult, and I think almost impossible to properly have a witness examination. And obviously, it depends on the tribunal. I think tribunal members who have been counsel and worked, as counsel, maybe 5-10 years before they started to be full-time arbitrators, they may appreciate the arguments a little more than maybe your arbitrator that's been just doing arbitration for 20-30 years. So it really depends on your tribunal.
Great, John. Thank you. And tying what you said in with what Darshini said earlier as well, this may play a role with the way that you're interpreting the dispute resolution clause itself. So if the clause is not clear on remote arbitration, like I've never seen a clause that was clear on this, you could have the party that's looking to delay to say, no, this is a complex dispute. We should wait for an in-person hearing. So that might give them an advantage, unless the tribunal takes the position that you implied, John, which is we're living in interesting times now, and you need to be flexible as far as this is concerned.
And I have to just say once before, because this is being taped, that the virtual hearing did proceed effectively 2 weeks ago, and so the parties were able to present their case in a reasonable manner. So I just want to make sure that I say that before we end.
Okay, great. And Sean and Darshini, did you have like a 30 seconds you wanted to add in regards to this question or about something else?
Well, I was going to say, Tony, that you know what you now find in procedure order number 1 is a provision or 2, which makes it quite clear that the tribunal has the ability to have hearings conducted fully virtually. And I've seen some language which provides for almost full discretion on the part of tribunals, and the way it's crafted is parties agree to it. So you put that right front center at the start, and that solves the problem.
Have you witnessed any pushback? Because I understand the strategy in putting that front and center, but have you witnessed one of the parties saying, tribunal, we understand what you're saying, but this is far too complicated for virtual hearing?
So far, no, not in my experience.
Darshini, did you have anything you wanted to add?
Not much, just a very brief point. I think going back to what I'd said earlier, you have to, for due process considerations or even considerations on compliance with the parties' agreed procedure, there's always a counter argument that of waiver. And so you often end up in this quite, I think, sensitive situation where, parties, as they're entitled to make their submissions on whether or not the proceedings should go to a virtual hearing or remote hearing, the tribunal then renders its decision, presumably saying, we will go ahead in XYZ format. And then what is it that the parties have to do? If you want to preserve your rights, you're in the slightly sensitive position of saying, we hear you, tribunal, but we will do this, but we're still going to preserve our rights. The risk there is obviously you don't want to alienate the tribunal by suggesting somehow, even before you've had a hearing, that they're doing something that's procedurally improper. I have not so far seen a case where a party has raised, at least in my experience, seen a case where parties raised objections and has continued to maintain those objections into the hearing. What I've seen is typically, they raise their objections, the tribunal makes a decision, and then they just go ahead. But obviously one thing to think about, and you should consult with counsel on this, is how to proceed or how to preserve your rights in the event a decision is made against you, that the proceeding goes ahead.
Thank you very much. Now, Tomohiro, we're out of time, but did you have a closing statement you wanted to make?
Sure, very, very briefly. So, like I said, unless the council seriously recommends that you should not do a certain hearing on a virtual basis, from a client perspective, I can't really see, although I raised some, technical issues, confidentiality issues and the like, I can't really see a situation where a client would say, no, we would not prefer virtual hearing for all the, benefits that I've just discussed. Cost, time is something that management really cares.
Great, thank you very much. And just to address one last question that came up a few times, people are asking about whether the JIDRC has empaneled arbitrators list. They do not. This is, as Professor Hayakawa said early on, the JIDRC is not an arbitral institution. It's a place to hold hearings. So we'd recommend that you turn to the institution such as SIAC or the JCA or KCAB, whichever institution you're working with, to get that list, or go off your own list. Thank you very much to SIAC. Thank you very much to the JIDRC. And thank you for this fantastic panel of experts. I got a lot out of it, and I'm hoping the audience did as well. Thank you very much, everybody. Stay safe, stay healthy. Thanks.
Thank you.
Thank you, everyone.
Thank you to all our speakers for those useful tips. I now like to introduce the speakers for the second panel, titled Strategies for Success: What Japanese parties Need to Know About Arbitration in Singapore and at SIAC. Moderating the session is Ms. Michelle Park Sonnen. The panelists are Mr. Chong Yi-Yen, member of the SIAC Board of Directors and the partner at Allen and Gladhill LLP, Mr. Hiroyuki Tezuka, member of the SIAC Court of Arbitration and partner at Nishimura and Asahi, and Ms. Lee Jung Chui, a member of the YSIAC committee and a partner at the Board and Board ATMD.
Thanks so much, Eriko, for that introduction. Hello again, everyone. I'm delighted to be back on your screens to moderate this second and final panel session of this evening. Our panel session is called Strategies for Success, What Japanese Parties Need to Know About Arbitration in Singapore and at SIAC. We have a really excellent panel of arbitration experts from Singapore, Mr. Chong Yi-byung and Ms. Lee Jun Choi from Singapore, and we also have Mr. Hiroyuki Tezuka from Japan. And I'm really delighted to have them here to help highlight some of the key factors that have turned Singapore into an international dispute resolution hub and made SIAC one of the world's premier global arbitral institutions, and how these factors benefit Japanese parties in particular. Singapore, I'm delighted to tell you, in case you don't already know, but Singapore is ranked among the top 3 most popular arbitral seats, and SIAC is among the top 3 most preferred arbitral institutions. We will also be talking about developments in the Japanese arbitration community and future directions that we can expect to see looking forward in Japan. We will try to address any questions that come up as we proceed. So if you have questions, please use the Q&A function at the bottom of your screens to pose them. Use the Q&A rather than the chat function. I have seen some questions come in through the chat, but the Q&A function is a better place to do that. So let's go ahead and dive in. I'd like to ask Lee Jun to get us started and provide an overview of the evolution of Singapore's dispute resolution system. Lee Jun?
Sure, thanks, Michelle. So I think we have prepared a couple of slides just to take us through the points. And I'm not sure if it's, okay, so it's going to be on the screen soon. And I wanted to approach this more from a personal perspective, just starting from the time when I first started practice about 15 years ago, what the arbitration scene looked at the time, compared to the level of success which it enjoys today. So I can't claim to be one of the pioneers in the industry. I think that privilege should be reserved for others, such as Yi-byung. I would like to say that I have quite the ringside seat in terms of how it's evolved. So if I could just ask that we move to the next slide. Look, from my perspective, really, I think these were the key ingredients in terms of the contribution to the level of arbitration adoption and usage that we have in Singapore, primarily as a sort of international disputes resolution hub. Just going through the points, I think perhaps that the starting integral point would be the legislation, which creates and fosters a lot of confidence in the product or service that we're trying to offer as arbitration. So Singapore was one of the first few to adopt the model law in terms of arbitration, a sort of lending the credibility and legitimacy to the arbitration service that we try to provide here. And I think a lot of people would know, for example, that there is a distinction in the legislation governing domestic and international arbitration. The point being that for international arbitration, meaning arbitration which involve parties that are not just in Singapore, would have less judicial intervention. So that's one of the features that makes it, I think, Singapore quite popular in terms of a dispute resolution hub. The other sort of bells and whistles that are quite encouraging would be, for example, in relation to the practitioners who might be available to support the service. So, you know, I think in the earlier days, there were quite a number of litigation lawyers in Singapore. So those who have been going to the courts for the decades, probably even, transitioning or pivoting to the arbitration industry. And of course, that formed quite a core group of arbitration practitioners to support the industry. But Singapore has also taken the approach of opening its doors towards foreign practitioners. So for example, Japanese lawyers can also represent clients in Singapore-based or Singapore-seated arbitrations, and that helps foster or encourage the growth of arbitration here. Perhaps I'll just move on next to the issue of neutrality for, sorry, if we can go back to the previous slide, neutrality for cross-border disputes. So as I mentioned earlier, there is a difference in the treatment of domestic and international arbitration. And Singapore is very attractive for international dispute resolution, cross-border disputes. And one of the key elements or ingredients to it would be the neutrality that is offered in this country, I think in many, many ways. But from a user's perspective, it's really having the confidence that if investors are coming into high-risk jurisdictions in this region, should things go completely pear-shaped, there would be the confidence that they could have the disputes adjudicated in a neutral forum with a fair and even result, instead of having to expose themselves to the vagaries of local courts, local jurisdictions, where in certain cases, a dispute could take up to 10 years to go to trial, not a great result, I would say, or where the infrastructure is far from ideal. So to give some very visceral and physical examples, there have been examples of courthouses which roof will be leaking during heavy rainstorms. And that isn't a great boost of confidence in terms of the ability of the courts to be able to give investors the fast and speedy and fair resolution that they want. So that leads me somewhat to the developed hearing infrastructure. I suppose quite a number of people would be aware of the, for example, Maxwell chambers. That's very much the physical infrastructure that we're talking about. These days, and we've heard so much about virtual hearings, that probably plays a somewhat smaller role. Although I think, as some of the earlier panelists have indicated, I think in-person hearings would always be the preference, and in which case it's quite important to have the appropriate and suitable hearing infrastructure, whether it be hearing facilities or even extending to issues such as accommodation, meeting rooms, etc. The last point I'd like to make in relation to this is the sectors and local economy, in the sense that I think the industries that tended to adopt arbitration as a means of dispute resolution, for example, maritime shipping, construction, etc., would be those that feature quite prominently in the Singapore local economy. So in a sense, arbitration was not something which was entirely foreign, and it was a very organic evolution and growth based on the sectors and services that are already available here. So for people to have to transition from litigation or rather court-going proceedings to arbitration, it's not that much of a difficulty, and it's going to be, I think, a lot more comfortable for them because it's already a service which is familiar to them in at least the key sectors here in Singapore.
Thanks, Lee-Jin. That was a really comprehensive overview. If I, could add a comment and maybe just a very quick follow-up question going back to legislation. As I mentioned in my remarks earlier, Singapore has always been at the forefront of amending or adapting legislation to make arbitration more successful and to make it more accessible. And so examples of this might be third-party funding legislation, emergency legislation that allowed emergency arbitration awards to be enforceable in Singapore. Do you want to say a few comments about that and what that's been like to sort of watch from the ringside seats?
So I have to say that in keeping with sort of almost a national policy of trying to encourage and foster innovation and businesses here, the Singapore arbitration legislation had recently undergone some amendments in keeping with the needs of users. So one of it would be confidentiality, which is something already enshrined within the SIAC rules and quite a number of the institutional rules, but given more teeth via the legislation. And the second one is really around appointment of arbitrators in a multi-party setting. Again, I think we'll see that the institutions had taken the lead on these issues. I think very much setting the pace, but you get a lot of support from the legislation side when they start amending the legislation to adopt such changes as well.
Great. Thank you so much. So we'll come back to Lee Jin in a minute, but if we could turn over to talk about the Singapore Judiciary specifically, and I know Yi Leong has got some comments there. And you know, the Singapore Judiciary is well known for being supportive of international arbitration, but not interfering with the arbitral process. And so if I could invite Yi Leong to elaborate on the approach of the Singapore courts to resolving disputes arising out of arbitration.
Sure, thanks very much, Michelle. I think I have some slides as well, which I prepared for this. Can those slides be brought up? Yeah, thanks very much. Okay, just like what Lee Jin said, I have been following the development of arbitrations in Singapore since I started practice. And the judiciary actually has come a long way since the old days, or rather I would say the bad old days. An illustration of that is actually back in 1987, when the High Court actually disallowed a foreign lawyer from representing a parties in arbitration in Singapore, because they say that it was in breach of the Legal Profession Act in Singapore. And foreign lawyers are not allowed to practice law in Singapore. And similarly, in the same arbitration, the arbitrators was removed for misconduct because he was found to have been biased. Now, those were what we call the bad old days, when the court was quite jealous of its jurisdiction and was quite keen to intervene in terms of the proceedings in arbitration. And just a little bit of a fun fact. In fact, in those two hearings, our current Chief Justice was the counsel for the party that actually sought the court intervention in those cases. Now, should forward to 30 plus years now, and the court approach is completely different. Now, if you can just move on to the next slide, please. Now, you can see that those are some of the cases that I have introduced, AKN and ALC. That's the case where the Court of Appeal in 2015 said in no uncertain terms that they respect party autonomy, and court do not and must not interfere in the merits of an arbitral award and bail out parties who have made choices. And most importantly, they affirm the policy of minimal courier intervention. That means that they say the court should not intervene, and the court should let the arbitrators and the arbitral proceedings proceed as intended by the parties. And in fact, if you look at the grounds for challenging an award, it is actually very, very narrowly prescribed. We follow the model law in Article 34, and the grounds for intervention are restricted to matters relating to jurisdiction, to process, and to public policy. And this is what the Court of Appeal again say in the case of Sobing T. They say that aggressive judicial intervention can only result in prolonging the arbitral process and encourage myriad unmeritorious challenges to arbitral awards by dissatisfied parties. Left unchecked, an interventionist approach can lead to indeterminate challenges, cause indeterminate costs to be incurred, and lead to indeterminate delays. So that is very much the Singapore judicial approach to arbitration. And I just like to illustrate that a bit more with the in two areas. There's first of all in challenging award. I already alluded a bit to that already, but in Singapore it is made very clear by the court that there is no appeal on the merits, no second bite at the cherry. Okay, so a party who is unhappy with an award can only apply to set aside the award, but the grounds for setting aside, as I said, is very narrow, and it only deals with jurisdictional issues. For example, where the arbitral tribunal dealt with issues that are not referred to by the parties, or the tribunal dealt with issues that are not covered by the arbitration clause. Due process, for example, when there are breach of natural justice, when parties are not given the opportunity to present their case, and public policy, such as fraud, arbitrability, and the Court of Appeal again has said it very clearly that public policy is going to be interpreted very narrowly, and it's only award that shocks the conscience of the society will be set aside. Now, there are some jurisdictions that have used the public policy ground very widely, and even say that arbitral award that's decided based on wrong law is against public policy, but that's not obviously the case in Singapore. And therefore, only a handful of awards in Singapore has been set aside. The next area that I would like to use as an illustration of the approach by the court is in terms of interim measures to support the arbitration. Now, Singapore courts is very, very supportive when it comes to supporting the arbitration, and there are interim measures that can be granted by the court to support arbitration. And the first point I'd like to make is that under our International Arbitration Act, the court actually can grant interim reliefs for arbitrations, whether the arbitration is seated in Singapore or outside of Singapore. So they support even arbitrations that are outside of Singapore. But they have also made very clear, the court has made very clear that they will only entertain parties going to them for interim measures if the court, or rather the parties cannot have access to the tribunal. What this means is that if they can get the interim measures from the tribunal, they should go to the tribunal first and get it from the tribunal. And in fact, even if the tribunal has not been formed, SIAC rules allow for emergency arbitration, which is something that actually is quite popular in Singapore at this moment. Although SIAC is not the first institution to introduce this emergency arbitration concept, it is in fact the most successful institution when it comes to emergency arbitration. And the court have said that if you can have resort to emergency arbitration, you should go there first before you come to the court to get interim measures. And obviously, all these interim measures that are issued by tribunals is enforceable in Singapore by way of leave of court. So you get the interim measure, or the parties affected by it refuse to comply, you can go to Singapore. So those are very briefly the two areas for me to illustrate the court approaches to arbitration. Thanks.
Thanks very much for that. Sorry, can I just check if you guys can hear me? My headphones ran out of battery. Yeah.
Loud and clear.
All right, thanks a lot. Thanks a lot, Yulong. That was a really good and comprehensive overview of the courts. Is my understanding correct that the judges in Singapore, there are actually some special judges that are designated to take on arbitration matters?
Yes, we have judges who are extremely experienced in arbitration. First of all, I would say our chief justice is. Can you hear me? Hello. Yep. Okay.
Sorry.
Yeah.
Okay.
Okay. Now I would just say first of all that our chief justice is extremely experienced arbitration practitioners before he went up to the bench, and in fact he is leading in a lot of the groundbreaking judgment that's delivered by the Court of Appeal in Singapore. And on top of that, we have a number of arbitration practitioners who are now have been elevated to the bench. The latest appointment is actually Mr. Philip Jeyaretnam, who is due to start as a judicial commissioner on 4th of January 2021. And of course, Mr. Jeyaretnam is a well-known arbitrator and well-known arbitration practitioners in Singapore and in the whole region. So yes, we do have some very, very experienced and knowledgeable judges who can deal with the arbitration issues that are brought to court.
Yeah, I think that that's really one of the many remarkable things about the Singapore judiciary is just the extensive knowledge and background in international arbitration as well, that you may not find that in other jurisdictions. All right, let's move on a bit and talk a little bit about the due process paranoia issue. And I think we're going to stay with Lee Young here, actually, because this is a bit related to
Sorry, Michelle, I think you broke off. Couldn't hear you for a while.
Sorry about that. I'm not sure what's going on with my headphones. I have them closed and everything, and they keep sort of taking over. Sorry about that.
No problem.
So we could talk a little bit about due process paranoia, because I know that that is a hot topic right now in some international arbitration circles, and I think that this is judiciary approaches, the way the judiciary.
Hello, everyone.
Yeah, okay.
Oh, I'm so sorry. I don't know what's going on with my headphones. They're like have a mind of their own. I keep putting them away and they still connect to the Bluetooth. My apologies for this. But anyway, if I could turn back to Elion to speak about due process paranoia, and I'll hand you the floor, and I'll sort this problem out.
No problem. Thanks, Michelle. I suppose that illustrates some of the problems that one might face with a virtual hearing. Yeah, due process paranoia. What is due process paranoia? Well, due process is actually a very important concept in arbitration, right? Because due process serves the legitimacy of the process. And what is due process? Due process essentially means that parties should be given opportunities to present their case. Each party must be treated fairly and equally. And the procedures of the arbitration must be observed so that whatever results that come out, whatever awards that come out will be respected. Now, so therefore, due process actually occupies a very central place in the whole arbitration process. And it deals with parties being given proper notice, deals with parties being given a fair opportunity to present and prepare their case, deal with parties having a neutral and unbiased tribunal. Now, it can't be a bad thing, right? But obviously, as with anything, too much of a good thing can be bad. The thing is that if you look at due process, there is the survey, a Queen Mary survey in 2015, that respondents say that there is a growing concern that there's a perceived reluctance by tribunal to act decisively in certain situations for fear of the award being challenged on the basis that parties are not having had the chance to present a case. So tribunal has become very indulgent of parties delaying the proceedings. Then parties say, I want more time to prepare my case, or I want to introduce certain documents late in the day, or I want to be given more time to do my cross-examination. The tribunals have been getting, has become very indulgent to such requests. And because they are very concerned that if they don't, parties at the end of the day might complain that they have not been given a full opportunity to present the case and the award can be set aside. And in fact, that's what happened in a recent case in Singapore called China Energy Machine and Jaguar Energy Guatemala. Okay, and in that case, okay, one of the losing parties actually complained that they have not been given proper access to certain documents and they have not been given sufficient time to prepare the report. And the court says that, well, we will have to look at this due process issue very carefully because we have this opportunity to review the situation. And may I have the next slide, please? Okay. And they say that, well, you look at it, okay. Article 18 actually says that parties, Article 18 of the model law actually says that parties should be given full opportunity to present their case. And each party have full opportunity, and if they don't get the full opportunity, the award can be set aside. But they clarify, they say that Article 18 does not give someone an unlimited right to present the case. Okay, it is impliedly limited by considerations of reasonableness and fairness. I have the next slide, please. So what is this reasonableness and fairness? It says what constitutes full opportunity is the contextual inquiry that can only be meaningfully answered within the specific context of the particular case. But the overarching inquiry is whether the proceeding was conducted in a manner that was fair, and the approach a court can take to ask itself whether the tribunal did or did not do something that fall within the range of what a reasonable and fair-minded tribunal would do. And in undertaking this exercise, the court said that you have to put yourself in the tribunal's shoes, in the sense that you would deal with it on the basis of the information that's available to the tribunal at that time. And the court should give deference to the tribunal in the matter of procedures and should not intervene simply because it would have done things differently. So the court has made it very clear. They're actually on the side of the tribunal. They say that the tribunal should not be too diffident about their ability to manage due process. And they say that speed and efficiency is as much central expectation of the parties as is adherence to strictures of due process. So there is a balancing to be done, and the tribunal should not be too indulgent when it comes to allowing parties to present their case, or to have more time, or to have a more opportunity to cross-examine their witnesses. Okay, so I think we are a bit short of time, so I will stop there unless you have any question, Michelle.
I have lots of questions, but I will have to save them for another time. Thank you very much. Thank you very much for that overview of due process paranoia. I do think that's an interesting issue that's ongoing in the community right now, and we will see how it develop in Singapore as well as other jurisdictions. So at this point, let's dive deeper into SIAC in particular, now that we have a very good overview of the framework in Singapore. And if I could ask Lee Jun to take us through some of the key aspects of SIAC, looking at international arbitration from the user's perspective and specifically from counsel's perspective. Lee Jun, hand it back to you.
Sure, thanks, Michelle. So I think there are just 4 main points to be made in relation to what a user expects in a successful or a good arbitration. I think the first thing is really emergency relief. So Iriong has talked quite a bit about it, and it's increasing popularity with users, especially with, I think, the need to get injunctions and the like. So when we recommend dispute resolution process to our clients, very often that's the question we get asked, how about injunctions? Do we have to go to court? And the answer here now is that, look, you can go to arbitration to get it. Somewhat sort of associated with that would be an expedited procedure. So I think under the SIAC rules is for any dispute amount which is less than 6 million, you could ask for expedited procedure, which means that you get the award within, I think, 6 months of the commencement of arbitration. So the beauty of that is an abbreviated process that gets you the quick results that would be suitable for smaller size disputes. The other 2 points, really, consolidation and joinder. First, is not altogether new. As we all know, many contracts now are multi-party contracts. Many of the contractual relationships would be part of a chain. So it's very useful to be able to bring in other parties as and when necessary, especially when you're talking about multi-party contracts, simply in acknowledgement of how commercial relationships are structured these days. And it's also reflected, I think, in the changes to the Singapore arbitration legislation in having the appointment mechanism when you're talking about multi-parties. Now, last of all, the scrutiny of awards, I think, is a feature that can't be underestimated, in the sense that it builds confidence in the service and product that's being offered here, knowing that the registrar of the SIAC would be casting his or her eye over the draft before it goes out, making sure that there are no obvious errors, I think lends it a sense of credibility and legitimacy as well. So these are the 4 main points that I think would stress would be especially important in encouraging adoption of SIAC arbitration or any arbitration process, essentially, from a user's perspective.
Thanks, Lee-Jun. Yeah, I'm glad that you were able to highlight some of SIAC's time and cost measures, particularly expedited procedure, joinder, consolidation. These measures are all intended to help parties more efficiently and effectively resolve their disputes. We do have a number of others as well, including the early dismissal procedure. Parties can also consider using the ARBMIT protocol. A whole host of things that are in the rules to help arbitrations move along more quickly, more efficiently, more comprehensively. I could sit here and talk about that all day, but I think I should let someone else speak about it. So I will turn over to Hiroyuki, who's going to give us a bit of an insider's perspective about SIAC as a member of our SIAC Court of Arbitration, and tell us a little bit more about the SIAC Court and the role of the court and what parties should know about that. Hiroyuki, please.
Thank you, Michelle. And let me first start with expressing my congratulations to SIAC on reaching the historical 1,000 cases.
Thank you.
And I really very much like the first slide of Lee-Jun we have seen, but I would add SIAC specifically to her first slide as one of the major driving forces in making Singapore as the most successful seat of arbitration in Asia. And I would briefly talk about the role of the SIAC Court, which I also believe one of the major driving forces of making SIAC one of the most preferred arbitration institutions in the world. And I think I'm a rare example of serving as court members for both SIAC and ICC. So I'm in a position to see both organizations at the same time. And I would first like to emphasize that in SIAC Court, unlike the ICC Court of Arbitration, the court does not scrutinize awards, and awards will be awards are reviewed by the registrar or deputy registrar, and heavily supported by many counsel. But SIAC Court doesn't scrutinize award, but what it does is the decision on jurisdictional challenge, arbitrator challenge, consolidation joinder. But that function is generally performed by a kind of ad hoc committee comprising of 2 or more court members. And this is not the kind of standing committee of fixed members, but those who are suitable and available are called upon. And in my experience, the formation of such committee of 2 or more people, the maximum number I've seen is 3, but it's very, very quick. It can be a matter of a few days to constitute the committee and the committee members, including the busiest, some of the busiest arbitration experts in the world are expected to work diligently and quickly. So what makes such a quick resolution by the court is the very useful support by the Secretariat Council, who prepares a very useful case memorandum. But I think that such speed is one of the aspects which is preferred by many of the users who feel that SIAC arbitration procedure is quick enough and reliable enough at the same time. And court also discusses rules revisions and procedural issues, policy issues, at least annually by getting together in Singapore. And for example, talking about the expected procedures, we have discussed what is the best balance of the expansion of the applicable size of the case, but at the same time maintaining the parties' expectation that they have the full rights to represent their case. And if it is expedited proceedings, even if the parties agree to 3 members tribunal, it can be 1. So I think the balancing is very important. But the SIAC has ears to listen to the court members who are the arbitration experts from around the world. And ICC has more than 100 court members from many jurisdictions, but the SIAC court started with around 20 people, now around 40, but still a good size. So I will stop here. Thank you.
Okay. Thanks a lot, Hiroyuki. Maybe you could also shed some light on like how it is that the court members are assigned to certain issues. For example, you know, if you're our resident Japanese court member from Japan, does that mean you're sitting on all the applications involving applications from Japanese parties, or are you looking at a diverse group of applications from a diverse group of parties? Any light you want to shed there on how that works?
I don't think I'm assigned to Japanese cases because I'm Japanese, but maybe the availability of court members is probably very important. And many of the court members are very busy. So I used to decline cases, and also people belonging to big firms often find conflict issues. So I needed to decline undertaking such court member cases because of the conflict. But we have 30, 40 people, so we can find someone who don't have conflict and who have availability.
Good. Very interesting to know. I think parties are often curious about the workings of the court, and it is nice to have someone here to tell us about that, someone who's experienced it firsthand. If I could also, you know, talk about the SIAC panel of arbitrators and how that informs the appointment of arbitrators in cases. And if I could ask Iliang again to come in and just say a few words about that, and how, you know, what parties should keep in mind when they are appointing arbitrators and asking the institution specifically to make appointments. I think you're on mute, Iliang. Great. Oh, no, yeah.
Sorry. Yeah, okay. Actually, appointment of arbitrators is one of the most important jobs. And in fact, parties usually like to make their own appointments because they would know what their case is about, and they would find the suitable or appropriate candidate for that. But when parties cannot agree, for example, you have a sole arbitrator, or you have a panel of 3, but the 2 arbitrators, 2-party appointed arbitrators cannot agree on a chair, then SIAC court will make the appointment. And usually that is either the president of the court, or if it's not available, the deputy president will make the appointment. SIAC will make the appointment actually from the panel. SIAC has a very strong panel, roughly about 580 names on the panel, and they are all very experienced names that you can find all over the world. In fact, they are called from 42 countries in the world, and they contain some of the most luminaries and experienced arbitrator in the world. And there is also a specialist panel, like the intellectual property panel, or the construction, the engineering, procurement, construction panel, which will deal with the specific specialized contract that is being arbitrated. And it has a good mix of civil law and common law lawyers from background. And this list is actually reviewed every few years so that it can be refreshed and can be updated. And I just want to point out also that in terms of emergency arbitration, something that we talk about quite a bit, the SIAC actually make an appointment within 24 hours because it is so important and so urgent. Appointment will be made within 24 hours. And SIAC also monitor their arbitrators to make sure that they are efficient. If they are not efficient, then SIAC actually has a power to tax down their fees. That's a very powerful power tool to have. And I would just like to also end up with saying that there's also a lot of diversity in appointment. In 2019, for example, 36% of the appointments are for female arbitrators. And also SIAC also appoint younger arbitrators for the smaller case, so as to build the next generation for bigger case to come. That I will end there. Yeah, thanks.
Thanks, Yu-Leong. Yeah, exactly. Yeah, really diverse panel from esteemed practitioners and experts and arbitrators from all over the world. And I will say that when making appointments, the president of the court has immense knowledge of cases and issues. And so it's a great attribute of SIAC that our court is involved with the arbitrator appointments when we make them. If I could, so this is, part of the purpose of this panel is to talk about Singapore and Singapore and SIAC and how it got where it is, but also with an eye toward Japan and what Japan can learn from the Singapore experience and what it means for Japanese parties as well when arbitrating in Singapore and at SIAC. And so on that note, if I could turn to Hiroyuki as our expert in Japanese arbitration to sort of pull it all together for us and talk about what this means for the Japanese arbitration community.
Thank you. Can I have my slide 2? Yes. So before I turn to my slide, I wanted to talk a little bit about the statistics. I have found that in 2000, the SIAC caseload was around 50, and then it takes 8 years for the SIAC caseloads to reach around 100. And then it takes only 2 years for the SIAC to reach 200. And 2017, it goes over 400. And now we have over 1,000. So it's a remarkable growth. And the Singapore as a preferred seat of arbitration is also shown by some statistics of ICC. And in 2019, the ICC cases seated in Japan was 4 cases. And Singapore had 32. So this is the largest ICC caseload in Asia. But if you compare around the 400, 1,000 with 32. It seems to me that Singapore's success has been driven by the SIAC's success, and then ICC has also been a kind of a beneficiary of such development of SIC and the Singapore Judiciary in arbitration. And then I want to turn to my slide 2. The good news is that finally the promotion of international arbitration in Japan has become a basic policy of the Japanese government. And we are glad that our Ministry of Justice now supports JIDRC as an arbitration specialized hearing center in Japan. And I believe that the success of Singapore as a preferred seat of arbitration is heavily supported by the fact that it has Maxwell chambers, the very nice and ever developing arbitration specialized hearing center. And in my experience, when the parties negotiate the seat of arbitrations, one of the opposition to the idea of Japan being selected as a seat of arbitration is that, oh, you don't have any Maxwell chamber-like thing, so we need to go to a hotel room. But now we have JIDRC, that is a good progress. And another typical complaint or opposition to the idea of agreeing to the Japan-seated arbitration was the issue of the foreign lawyers' right to represent clients in international arbitration in Japan. And the situation was, I think, better than some other Asian jurisdictions, where sometimes there is a very wide prohibition of foreign lawyers' representation, particularly where the case involves any aspect of the local law. But there were some uncertainties and the trickiness of the definition of the international arbitration under the old law. So the good news is that the foreign lawyers' law has very recently been amended so as to expand as and also clarify the scope of representation by foreign attorneys in international arbitration cases. And another good news is that international commercial mediation is also the area where the new law has clarified the foreign lawyers party representation. This is very important because we now observe an increasing use or idea of using the hybrid dispute resolution mechanism combining arbitration and mediation. So even if we have some good foreign lawyers law, liberal law on international arbitration, if the law is not clear as to the party representation on mediation in the process of med, then it's another problem. So I think this is a good development. And we are now trying to update the Japanese arbitration law, which was enacted in 2003, but it's a few years before the model law was amended in 2006. So we could not catch up the 2006 model law during the last 15 years. But Finally, the Judicial Council has set up a working group on the discussion of amendments to the Japanese arbitration law to adopt the 2006 model law, which of course includes the idea of introducing enforceability of tribunals' interim relief. And the good news is that we are not going to stop there. We are also thinking about introducing some novel idea of special jurisdiction of Tokyo and or Osaka district courts on the arbitration related cases, so that judges specialized in arbitration related cases can handle those cases. And innovative idea is that we would expect to introduce some system where the court can dispense with the Japanese translation of the English documents. So it's something like a Paris International Commercial Code. So I hope that those are a very promising development. And I hope that in the next year, we will see good development in the legislative efforts. And I'm a member of the working group, and I hope to achieve those kind of progress. Thank you.
Great, thanks a lot, Hiroyuki. I do think that those are all very interesting developments, and we do look forward to seeing how the community and how the legislation and so forth develops in Japan. Especially interesting to see the changes to the law on foreign representation. And then also, you know, the possible development of courts where you don't need to submit English translations. I imagine that would reduce a lot of the resources required to bring enforcement proceedings or set aside proceedings in Japan.
Yes, I think so. So you don't have to prepare, 500 pages of a Japanese translation of the entire arbitral award.
Yeah.
So the judges are expected to read and understand the award, and maybe the sensitive part needs to be translated upon judge's request, but we can dispense with much burden. I hope.
And just out of curiosity, in the past, did you have to also translate all the evidence that had been submitted, all the submissions, or was it typically just the award?
No, just award. But if the grounds for setting aside or alleged refusal to enforce relates to the submissions or exhibits in English, they would have to be translated.
Yeah, that's quite an undertaking. We do have a somewhat related question, in that it also deals with enforcement. Question from the audience, and I think what the question is asking is the enforceability of SIAC awards. And we do have a few minutes remaining, so I just wanted to pose to the panelists: do you have experience enforcing SIAC awards in what we might call difficult jurisdictions? And if you have any personal sort of war stories or experiences you want to share with the audience, I would invite you to do that. Anybody have anything to offer there?
Maybe I can just share my experience. First of all, SIAC award, just like any other award actually delivered in Singapore, is recognized as a Singapore award, and therefore can be enforced in Singapore. And when I say enforce, it means that you can go to the court and register it, and then once it's registered, it's just like a court judgment. And on top of that, the most important thing is that because Singapore is a signatory to the New York Convention, Singapore award is enforceable throughout the world. in all the other New York Convention countries. So as a last check, I think it was 160 countries that have signed up to the New York Convention. So it is something that is actually quite unique, international in that sense. And I have experience enforcing SIAC award in Vietnam, in Malaysia, and in China. Obviously, different jurisdictions have different requirements to be complied with, but all in all, generally, I think SIAC award is viewed as something that is very, it's a brand name, right? It's actually very respected. And in fact, in countries that are deemed difficult, just like in Vietnam, SIAC award has been enforced, and parties have been successful in getting their reliefs has been given in the SIAC award.
I'd like to
would
just,
please.
sorry,
Go ahead.
Hiroki, please go ahead.
Okay, I would add that in under new convention or modern law, if the award is set aside in the place of the seat of arbitration, it may be the reason for refusal to enforce. But I would say that the SIAC award issued in Singapore, reviewed by the Singapore court, would rarely be set aside. So you see the minimum risk of that kind of scenario, that the award is set aside by the court of the seat of arbitration.
I just wanted to make the point that if a party has to pursue the opposing party and enforce the award in another jurisdiction, meaning that the defaulting party is not complying with the award in the first place, then I think it makes a better argument for arbitration as a service to begin with, because if you can imagine having to chase them in their own courts after getting an award in your favor, can you imagine how much worse it would be if you had to pursue them in their own courts in the first place? And the other thing to that really is that I think as part of the arbitration process, I've seen cases where the opposing party then comes to the table and the original or the prosecuting party then gets the result that they want. Simply because I think as part of the arbitration process, people are then forced to either comply with their contractual obligations or to act sensibly because they don't want to look silly in front of a tribunal. So I think when we talk about enforcement, really, it makes a much better case for arbitration, especially I think as a means of managing investment or business risk in this region or globally.
Great, thanks very much. And that does actually bring us to our the end of our allotted time. But if anybody has any very brief final thoughts that they would like to share, I think we could spare a few more moments for that. No? All right, we've covered a lot of ground and we've answered questions from the audience, and I do appreciate the panelists for being here today, sharing their experiences in Singapore and in Japan at SIAC as well. If there are any other comments and questions from the audience, do feel free to reach out to me in particular at SIAC if they pertain to us. I'm sure panelists welcome questions as well. So with that, thanks very much for joining us on behalf of SIAC. I appreciate you being here. And I think I can also wrap up on behalf of JIDRC, or maybe Hiroyuki can do that.
You can.
Thanks very much. Have a wonderful evening. We look forward to seeing you online at future virtual events and hopefully seeing you in person soon once things start to return to the old normal. Thank you, and have a great day.
Thanks very much, Michelle. Thanks, everyone. Bye-bye.
Thank you.
Thank you to all our speakers for giving the audience the insider view to arbitrating in Singapore and at SIAC.